Hello, everybody. My name is Emmanuel Wauters. I'm a member of the Employment Law Department at MVVP. And today's speaker is my colleague, Bruno Blanpain. I think that many of you have already participated to webinars and seminars given by Bruno. And today he will speak about a very topical issue, because he will speak about the homework systems and the new rules with regard to the right to disconnect of employees, new rules that have been introduced by a law of 3 October 2022. In the first part of his presentation, Bruno will explain which the different systems of homeworking are. And in the second part, the main part, he will speak about the new rules with regard to the right to disconnect of the employees. And I think that if there's one message that Bruno will give you today is that these new rules with regard to the right to disconnect do not only encompass administrative obligations, new administrative obligations for employers, but that these rules also aim at stimulating employers to think about which precise measures they can take, they must take in order to guarantee the right to disconnect of the employees, and to also to contribute to the well-being of their employees during the performance of their work. But now spoken enough, and I will pass the words to Bruno. Thank you.
Thank you, Emmanuel. Yes, I would like to start off with this slide to illustrate how lucky we are with regard to the tools and technologies that allow us to work in very pleasant environments. And we would like today discuss on where we have come from, what the status is, what the state of play is, and what you as an HR manager, as an HR professional, have to do to get ready and be able to deal with this new piece of legislation. So where do we come from? Well, yeah, our age is characterized by what they say to be hyperconnectivity. And in the 90s, our economies were faced with globalization, which has as a result an enormous increase of productivity and efficiency, and the fact that we are all working just in time with logistic chains. And this was all driven through digitalization. In 2000, we went to Web 2.0, where we have an interactive internet. Everybody, even your 8-year daughter, gets to have a smartphone. And we are all linked to each other through this device, where there is a new phenomenon coming up, the fear of missing out, where everybody tries to stay ahead of things happening around us in our community and also in our world. And therefore, we are really living on platforms where we have both the private and the professional lives coming together. So with regard to working time, we were in the previous generation able to ward off and fence off professional situations through distance and working time. That does no longer play a role, because we are now able, and we are connected, we are able to work everywhere all the time, and therefore our private space is now threatened to be colonized by our own profession. So this luxury of connection, which we had, we were all proud with our first smartphone, becomes now a luxury of disconnection. Do we have the luxury to stay offline and not have to answer that particular email? Which leads us to a new digital divide, where you are people who can no longer be separated from the net, can no longer be separated from their work, can no longer separate themselves from the so-called urgent matters that they have to deal with. And therefore, the problem that we are faced with is hyperconnectivity. And is that really the source of the problem, or is that problem that hyperconnectivity is giving us more linked with the expectancies of the organizations we work in and the corporate values that identify that organization? First, I would like to start off with some facts and figures in the United States of America to show really the leap forward that we have made as far as telework is concerned. And the figures are illustrating this great leap forward to the extent that in the United States in 2019 we had 5% of the total workforce that was occasionally and structurally telecommuting. And this leap forward was during the pandemic, for obvious reasons, to 60% of all workers in the United States that were working on an occasional or structural basis from home through means of information technology. Today, John Doe, so Mr. Average or Mrs. Average, 50% of all workers in the United States confirm that they are okay with working half of their total working time from home through telework. They are not alone, because the Wall Street, so the economists, they are all also happy with telework, because they have found that telework increases productivity, so that there is a business case to promote telework because it leads to more production, and therefore is profitable for the company. So the only person with a name who is pleading against telework in the United States actually is Mr. Elon Musk, who recently became the owner of Twitter, and who is known for the fact that he loathes, he hates telework, and he pretends and says that somebody who is asking for to do telework should pretend to work somewhere else, but with Tesla and Twitter. So let's go now to the facts and figures in the European Union, where pre-pandemic, 20% of all workers were working structurally and occasionally. Big difference between Southern Europe and Northern Europe, where respectively 8% and 32% were teleworking. And also this leap forward with regard to telework during the pandemic, where in July 2020, 37% of all workers in the 27 member states of the European Union were telecommuting. Let's go now to Belgium, where pre-pandemic, the same figures as in the EU were valid. 20% of all workforce, 81% of total workforce was telecommuting during the pandemic, where you had on a daily basis 33% and on a regular basis 48%. This leap forward was partially kept after the pandemic, where you have 22% of the workforce working from home on a daily basis, of which 45% at least works 1 day per week. 6 out of 10 workers want to continue or have even do more work from home. 80% of all employers are positive with regard to telework because they find that employees are more efficient and more productive. And 90% of all employers that were questioned confirm that they plan to continue with telework in the near and foreseeable future. So to go over the advantages and the challenges of telework, telework allows the employee more flexibility and allows him or her to reconcile work and private life. And that creates productivity gains for the employer, and that allows also the employee to work autonomously and to organize his or her own day during working hours. The employee obviously has to spend less time commuting from work to home and from home to work. And therefore, it allows the employee to be more innovative and also creates cost savings. Not to speak about the fact that it also has a gain for the environment, makes the Green Deal possible, the decarbonization of the economy. We talk about telework as an instrument, and needless to say that teleworking helps to avoid traffic jams and make these hampers on the traffic dissipate. The challenges for telework, as with all good things, are that telework blurs lines between professional and private life. And this obviously has some consequences with regard to physical and psychosocial issues. There are health and safety issues that are consequenced by the fact that we stay connected at all times, or the possibility that we stay connected at all times, and that we cannot really turn our professional life off. Also, telework impacts on the access of teleworkers in social dialogue. So if they are involved in the working of the workers' representation in the Works Council or a trade union delegation, the fact that they are less present has an impact. It may also have an impact with regard to training. Onboarding becomes more difficult of newly hired employees. There may also be issues with regard to career prospects and the organization of the workplace. Telework may also have an impact on the gender divide, where mostly female workers prefer to stay home for work. So they may have less career chances, and this may also result in telework may also result in a digital divide, to the extent that we are no longer being able to fend off our work in our private life. Yeah, there is also an issue with regard to cross-border telework, which has consequences with regard to social security and tax issues. This goes beyond the realm of this presentation, and I'm certain that MVVP will organize a webinar later on to deal with the issues resulting from cross-border telework. So when we talk about occupational safety and health issues, with regard to stress, I would like to refer to a recent article of October in the Tijd, where it was reported that there is a dramatic increase of incapacitation to work, a dramatic increase of sick days, to the extent that there was a 20% increase this year to 5.8 days, sick days that for each worker in Belgium was reported end of September, which brings, if you extrapolate this to a whole year, brings us to 8 days as a yearly annual average of sick days. Statbel reported for 2020 that 622,000 workers had health issues that were related to their occupation, to their profession, of which 55.4% of the complaints had to do with bone, joint, or muscle complaints. And 25.9% were caused by stress, depression, or anxiety. And what is interesting here is that the pool of highly educated workers, their stress, depression, and anxiety were more frequent than the other major complaint of bone, joint, or muscle complaints. So there is indeed a report with regard to the fact that overwork and high time pressure impacts on mental health, and this impacts on the well-being for 22.4% of the total workforce in Belgium. So that to show that there is an issue with regard to stress, depression, and anxiety in Belgium. With this backdrop, it does not surprise that the social partners on the European level concluded a framework agreement on digitalization to deal with this hyperconnectivity issue and the impact it has on the health of workers, with negative consequences resulting from stress, anxiety, leading to depression, to burnouts. And so they concluded this framework agreement on June 22nd, 2020, in which the right to disconnect, the right to stay offline and not have to deal with urgent, so-called urgent matters for workers was agreed. So we would like now to briefly look over the existing legal environment which deals with this issue of hyperconnectivity. And first of all, I'd like to mention the labor statute, obviously, which deals with daily and weekly hours, rest periods, and night work. Secondly, is relevant is the statute respecting the well-being of 1996, where the employer has the obligation to deal with risk prevention, and he has to adapt that risk prevention in view of changing circumstances. So hyperconnectivity is a changing circumstance, so the employer has to deal with this issue. There is the collective bargaining agreement number 85 bis, which deals with telework, and in which the social partners said that there was a very important component with regard to occupational safety and health issues. Unfortunately, the social partners that at the time did not really go into detail with regard to these issues. The statute called Peters on workable and agile work of 2017 that introduced occasional telework, in contrary to 85 bis that dealt with structured telework. Then we have the statute on strengthening economic growth and social cohesion of 2018, which introduced to Belgian law the privilege or the right to disconnect. We have the collective bargaining agreement number 149, which deals with occasional telework, specific aspects of occasional telework during the pandemic, and which gives a lot of attention to occupational safety and health issues, which is not surprising during a pandemic. And then the collective bargaining agreement 161, which was recently concluded on transparent and predictable working conditions, and the collective bargaining agreement 162 on flexible work for parents and carers, to show that the authorities and the social partners, the government, the legislator, and the social partners really deal with these issues of stress, anxiety, and depression, and that they are and want to create a legal environment where these issues are being addressed. The privilege or the right to disconnect, as I said, was first introduced in 2018 by the statute on strengthening the economic growth and social cohesion. There was no real right introduced, to the extent that it was more a proposition by the legislator for a team to discuss in the prevention committee. So as you know, prevention committees only have to be established in undertakings with at least 50 workers. So that statute, though, gave a roadmap for this discussion topic, privilege to disconnect, in the prevention committee within the obligation of dynamic risk prevention by the employer. And it suggested that if some kind of an agreement, some kind of a deal be struck with between the two benches, between the employer's bench and the employee's bench, that this could be put into a collective bargaining agreement or work rules to bring this privilege to disconnect in a hyper-connective world forward. And now we recently adopted the statute containing various labor provisions, the so-called employment deal, where with regard to the privilege to disconnect, the statute that firstly introduced the privilege to disconnect in 2018 was amended, and where now, where before it was not mandatory to strike a deal with regard to the privilege to disconnect, it is now mandatory to regulate within each undertaking the privilege to disconnect, be either that in a collective bargaining agreement or the work rules, and the statute also amended this not only as a mandatory obligation to strike a deal, but also with regard to the fact that now undertakings that are employing more than 20 workers must introduce this by this deal with regard to the right to disconnect prior to January 1st, 2023. So if you have not started yet, because the statute was only published in the Belgian State Gazette on November 10th, came into force on November 20th, and January 1st, 2023, so 41 days to strike a deal with the unions, or either amend the work rules seems to be a very heavy lift, and also the Ministry of Labour was saw also that it was unfair to impose that to employers. So immediately a few days after the statute respecting various labor provisions, the statute on the employment deal was published, they already confirmed on their website that they were not going to prosecute employers if they were not ready by January 1st, and gave 3 more months to get the privilege to disconnect sorted. The question of obviously is whether this is the obligation of the executive branch of the government that has to execute statutes and does not have to postpone them. So that is obviously a theoretical remark. I guess employers will be happy to learn that they have a little bit more time to get the privilege to disconnect sorted. But it makes you wonder with regard to the way we make statutes impose obligations on employers to get this honorable goal and of alleviating stress, alleviating anxiety and depression with employees, how they try to attain that. Now, when we look at the statute respecting the labor deal, we can't find really a definition of the privilege to disconnect. We have to look at the goals that are attained to understand exactly what the legislator means by the right to disconnect. Yeah, it's a little bit mirroring the French law El Khomri, where in 2017 the privilege to disconnect was introduced, where there is also no definition about this right, about this privilege. And so we have to understand through its goals that are determined in the statute on what it really means, this and what it entails, this right, this privilege to disconnect. So the first goal is the regulation of the use of digital tools, where this regulation is made with a view that rest periods of workers are respected. In the statute, the first version in 2018, the goal was a guarantee of a balance between private and professional life. The current wording of the labor deal statute does no longer mention a guarantee. Yeah, I think that would bring things too far for the employer to guarantee the balance between private and professional life, because that is also a task for the employee to find his own equilibrium on what he prefers to have as a balance. But it helps us to understand that this is the goal for the regulation of the use of digital tools with respect to the rest periods, in order to allow a balance for the employee between private and professional life. And that regulation must, in accordance with the labor law or the labor deal statute, be determined by a collective bargaining agreement or through the work rules. And it must provide in a minimum content, of which we will talk later. So the obligation to install this privilege to disconnect must be the object of a collective bargaining agreement or an amendment of the work rules. When obviously the collective bargaining agreement regarding the privilege to disconnect, the right to disconnect, is concluded at a higher level than the undertaking, then you do no longer have that obligation. But I have done, before this webinar, done some research with the banking sector and the National Labour Council, and asked them whether they were able to or they were going to make a collective bargaining agreement to regulate the privilege, the right to disconnect. And I found, I got the answer from the National Labour Council, yeah, we're working on it, but it's not sure that we will be able to get something out. In the banking sector, the sectoral agreement for the next 2 years mentions this right, but does not work it out. So it doesn't contain the minimum content, so it does not bring or alleviate or relieve the employer to conclude this collective bargaining agreement or work rules. And the reason being that the equilibrium with regard to the respect of rest periods and the regulation of digital tools in professional life, that each undertaking is best placed to regulate this. That is my opinion, but obviously the practice, the proof of the pudding is in the eating. We will see how it will all turn out. But if there is a collective bargaining agreement that must be, and that is concluded then at the level of the undertaking, it must be registered with the Ministry of Labor in accordance with the statute on collective labor agreements. And if you do regulate the privilege to disconnect in the work rules, that those work rules or that amendment has to be registered with the social inspection, and that can, since 2017, be done electronically. You will find the information on the Ministry of Labor's website. So what is the minimum content that is mandated, that is imposed by the statute on the labor deal to the employer and the employees to conclude a valid collective bargaining agreement, a valid regulation in the work rules respecting the privilege to disconnect. So first of all, it must provide in practical arrangements when the employee can not be reachable outside working hours. So if there are urgencies, who is going to deal with these urgencies? So that because employees are also responsible people, and to give them a peace of mind, the first thing they have to know is that it is being sorted. If they turn off their computer, if they turn off their tablet and their smartphone, that they know that the whole place is not going to blow up, and that all clients are not going to be in trouble and leave the employer, so that the next day there will be no longer a job for him. So that is an important piece of information that has to be addressed in the collective bargaining agreement or in the work rules. Secondly, guidelines must be provided for regarding the use of digital tools to safeguard and to respect the rest periods, the leave of vacation of the employees, and to respect the private life and the family life of the employee. So these guidelines must be agreed with between management and employee representatives. And thirdly, which has to do with the manner in which people work together, and in the way the company deals with so-called urgent issues, so that there is training and awareness for employees and managers respecting the sensible use of digital tools. Everything is about moderation. Digital tools are fantastic, allow us to work everywhere, to regulate our work efficiently ourselves, gives us much more authority on how to live our lives. But they must be used with moderation. So how to use them sensibly, and to be able to distance yourself and turn it off. And secondly, the risks that are associated with regard to excessive connection, so that everybody is aware of the fact that hyperconnectivity is, when not used wisely, can be a risk factor for your health and can be a safety issue when not properly used and addressed by the hierarchy, by the undertaking, by the organization. So when we are faced with this obligation to strike a deal on the right to work, I would like to make a proposition with the regard to the format of the social dialogue that should be formed around the privilege to disconnect in an environment where you are no longer able to use location and time to fend off your private sphere from your professional sphere. And first, I would suggest that management and the workers' bench first establish the state of affairs, the current state of affairs in the undertaking with regard to this issues of hyperconnectivity and or how work is being organized. So where the needs of the organization, needs of workers are being listed up, and that everybody gets to know what each other's expectations are with regard to the current state of play. Secondly, I would suggest that the discussion is maintained around or made around the application of the existing general framework of in the company, in the undertaking with regard to working time, the rest breaks and the leave, how it is applied, whether it's respected or not, how everybody looks at it, and whether there are things to be improved. Then I suggest that the management representatives and the worker representatives discuss the special modalities in the undertaking with regard to telework, variable hours, part-time work, all things that allow flexibility and which present specific issues in the light of hyperconnectivity and the fact that there is no longer the location, the place of work, and the time to fend off private life from professional life. Then everybody should have their view on what the pitfalls are of the issues presented, and then both benches should talk about how they should and would want to amend the legal instruments. So drafts have to be exchanged between management representatives and worker representatives, where these instruments are going to be or have to be in accordance with the statute agreed, and then how they are going to move awareness forward with regard to these issues on hyperconnectivity, where there is a change, or maybe a change in the organization on the way on how it deals with so-called urgent matters, and that it's okay to turn off your professional phone after working hours, because there is somebody who is going to deal with urgent matters, but that you are therefore no longer don't see the necessity to check every 15 minutes your professional email, or check whether you didn't miss a professional call from somebody else in the organization. So what are the sanctions? As a lawyer, when we are talking about an obligation, about a mandated collective bargaining agreement, a mandated amendment of the work rules, some clients ask, yeah, what if I don't do that, and I don't comply with this new set of rules? Well, you at first sight, you may be happy to learn that there is no specific sanction provided for in the labor deal statute and in the statute of 2018 respecting the obligation to introduce a right to disconnect in your organization. But don't be happy too fast, because the right to disconnect has linkages with working time, with occupational safety and health issues, and with social dialogue and the way social dialogue is organized within the organization, within the undertaking. And if we look at the social criminal code, the social penal code, we can report to you that with regard to working time and the right to disconnect is linked to working time, because it obliges you to respect rest periods. You must know that issues with regard, or offenses against the working time statute gives rise to class 2 offenses, which are enforced to fines up to 4,000 euro for each worker. So if you have a large organization, that can become very expensive. With regard to occupational safety and health, the penalties are even stiffer, severer, and they go for a class 3 up to 8,000 euro. And if as a result of stress, anxiety, and depression, somebody is really getting hurt, so there is physical damage or as a result of these offense of not applying occupational safety and health legislation, of which the right to disconnect forms a part, then it can become a class 4 offense, which leads to jail sentences up to 3 years. So something to take into consideration. And yeah, obviously, if you do not discuss the right to disconnect within the prevention committee, it could be considered to be an obstruction of the working of the prevention committee, which is also a class 2 offense. And therefore, I would say that this new statute is not without teeth. It can be enforced, and that the press release of the Ministry of Labour with regard to not prosecuting and the fact that there is no collective bargaining agreement or an amendment of the work rules respecting the right to disconnect by the 31st of March 2023, that this is not bluff, and that they sure have cards in their hands to enforce this statutory obligation. So yeah, are we going to squaring the cycle? When I was announcing this webinar, I was trying to draw your attention to the fact that there is some called an impossibility to bring telework together with the right to disconnect. In fact, I was putting you on the wrong foot to the extent that I was just trying to draw your attention. Because yeah, teleworkers can organize themselves during working hours, their own work, and so they have a very a lot of autonomy in the organization of their working day. So that explains why some teleworkers who are shopping during working hours, or going bringing kids to school and bringing them back from school to house, that all these actions are considered to be industrial accidents, because they are being they are happening during working hours. So it shows that our legislation goes very far in allowing the teleworker to organize his working day himself during working hours. And when we are talking about the right to disconnect, that is something else than the right to be or the obligation to be reachable, because the telework agreements have to although the worker can organize himself, he must not during working hours, he must not at all the time be reachable for the employer. He may be in a meeting with a client or another colleague, and therefore not be reachable. But the teleworking agreement must provide for a specific period in time in which the employee is reachable, which is something else than the privilege to disconnect, because that is a guarantee from the employer that the employee can be unreachable, that there is no obligation for the employee to be reachable. So these are two different concepts, two different rights, which do not contradict each other. The teleworker can be during the working days, during the working day, it can be reached. He does not have an obligation to be reachable all the time, only at the period in time that is determined by the agreement with his employer. After working hours, he does not have to be reachable. He can be unreachable, and that is a guarantee by the employer. So the employee gives a guarantee to be reachable during working time on specific moments in time, and the employer gives the guarantee to the employee that he can be unreachable after working time. So these two concepts of telework, being reachable, and employee organizing his working time himself, is not contradictory to the privilege to disconnect. These are two different concepts, and therefore there is no really obligation to square the cycle. Both rights, both privileges are perfectly can perfectly be used to regulate the phenomenon of telecommuting, of telework. And what we have to take away from these two different rights is that the employer is advised to really determine the working hours on a sliding basis, so that he allows between, for example, 8 o'clock in the morning and 20 hours at night, the employee who is still working to organize his working time during this period of time, during these 12 hours, and that therefore he can try to reach the employee during the working time, the employee who's bringing his kids to the school or doing shopping is not obliged to pick up the phone when the employer is reaching out to him. Yes, he's obliged to pick up the phone at the moment in time that he has to be reachable, when he guarantees to be reachable. But after 20 hours at night and before 8 o'clock in the morning, the employee can be unreachable, and that right to be unreachable is being guaranteed by the employer. So the conclusion of this webinar is that there is a difference between reachability and disconnection. These are two different concepts that are not necessarily contradictory. There is a continuous search for an equilibrium where you have to find a solution in view of hyperconnectivity and the work to be done in the undertaking, where it's going to be very difficult, I think, to make a one-size-fits-all solution at the industry level or at the national level, but where undertakings themselves, through the work rules and the collective bargaining agreement at the undertaking level, are best placed to find a solution and to address this hyperconnectivity with a view of respect for the rest periods of employees, where there is a platform to be found where in a new area where place of work and time are no longer instruments to fend off the professional private life from your profession, but where employer and employee must find each other on how to best organize themselves around these new tools and these fantastic instruments that we have to autonomously organize our professional lives. All this is obviously an ideal subject to conduct and to maintain a social dialogue within the undertakings. And I would like to end this webinar with a saying by Oscar Wilde that is also applicable in this area of hyperconnectivity, where we are dealing with alcohol, cigarettes, and everything which makes life, which colors life. Everything in moderation, including moderation. So also with regard to social dialogue, everything in moderation. Thank you very much for your attention, and please feel free to ask questions after my presentation. Thank you very much.